All right, we'll open our panel discussions today with the first panel, which is Protecting Tribal Existence and Tribal Sovereignty.
Thanks, Carla. Hi, everybody. Attorney with the Native American Rights Fund DC office. And it's a real pleasure to be here for everybody today, and especially to moderate this panel on the protection of tribal existence and tribal sovereignty. Of course, that's a very broad, big topic, so we had to find some ways to narrow that down a bit. So we're going to focus in on ways in which the protection of tribal existence and tribal sovereignty has been accomplished through legislation, litigation, regulation, but also, I think importantly, in the ways that tribes have asserted themselves in that governance space, and thereby preserved existence and tribal sovereignty. And we have a really fabulous panel to talk about those things here today. So I'll give you kind of the high points of their very long and impressive bios, all of which are in your conference materials. But they said just give the high points, so that's what I'm going to try to do here. Arlinda Locklear is a citizen of the Lumbee tribe, North Carolina. Her career began as a NARF attorney in 1976, and she was with NARF until 1987. Among her many accomplishments as an attorney, she was the first Native American woman to argue a case before the United States Supreme Court. And she is currently in private practice in Washington, D.C. Ada Deer is a citizen of the Menominee tribe of Wisconsin. She has the unique distinction of being first a NARF client, then an employee, a board member, and then a board chair. So quite unique in that way. She was also Assistant Secretary for Indian Affairs from 1993 until 1997. She's currently a lecturer emerita at the University of Wisconsin. Melody McCoy is a staff attorney with the Native American Rights Fund in the Boulder office. She's a citizen of the Cherokee Nation, and she has been a past chair of the Federal Bar Association Indian Law Conference, past president of the Colorado Indian Bar Association, and a past board member of the Native American Bar Association. And she is currently a member of NARF's Litigation Management Committee. Tom Fredericks is a citizen of the Mandan, Hidatsa, and Arikara Nation. He was executive director of NARF from 1975 until 1977. He was also an assistant secretary for Indian Affairs and is currently a partner at Fredericks, Peebles, and Morgan. So please welcome this panel. And we'll start with Arlinda.
Thank you. Good morning, everybody. I'd like to start by taking a point of personal privilege, if I may. The Native American Rights Fund, as Charles so eloquently explained to us, is a unique and wonderful organization. I was the first Eastern Indian that was hired by NARF. Tom Fredericks took a big chance on me in 1976. Not only was I Eastern Indian, but I was a member of a non-federally recognized tribe, and the most controversial non-federally recognized tribe to boot. Nonetheless, Tom hired me, and then I had the great advantage of being trained by some of the best lawyers in the business, including John Eckelhawk, Bruce Green, Rick Collins, Yvonne Knight, even though I had no academic training in Indian law when I was in law school. So I owe to them my career, the development of the passion for this law, and I'm very grateful for their vision and for their personal contribution to my career. In fact, let me say one additional point in that regard. John may not even remember this, but when the Solem v. Bartlett case was assigned, that was the first case that I did at the Supreme Court, I was a real young lawyer, just barely old enough to practice before the Supreme Court, and all of the wise heads in the business told John that that was not a wise move, that he should assign it to some of the more senior staff or let someone outside NARF do it, and he said, no, I think we've got this. And he insisted that I would do it, and I appreciate that. Thank you, John. That being said, that gets us to the subject today, tribal existence. This is a subject that is near and dear to my heart as a member of a non-federally recognized tribe because it goes to the core of what we all do. It is the fundamental issue. And I think it's important that this be addressed by a non-federally recognized Indian because it does not depend on federal recognition. It does not depend on any act of bestowal by the United States. In fact, it exists as a matter of sheer political will by the Indian communities that exercise it. It exists because Indian people, indigenous communities, decided on their own, through their own political processes, that they would maintain themselves, maintain their independence, and continue to govern themselves through their own traditional means. That's what tribal existence means. It doesn't depend on any act of bestowal from the United States, any state, or otherwise. As a result, it exists whether an indigenous community is federally recognized or not. And it is the fundamental concept of federal Indian law. All other rights flow from this, with one significant exception, and that is the so-called half-blood exemption in the Indian Reorganization Act in 1934, which does bestow individual rights on so-called certified half-blood Indians. But apart from that major exception, all the rights that you'll hear about today and that are discussed, including that fundamental attribute of sovereignty, flow from tribal existence. So it is the basis of all federal Indian law. And it is one of the first priorities of the Native American Rights Fund. In their wisdom, the first board of directors of NARF set a set of priorities to govern the decisions that would be made in terms of cases that would be taken and self-conscious efforts to develop a favorable body of federal Indian law with regard to those issues. Tribal existence was one of those. As a result of NARF's work and the influence of others as time passed, the tribal existence issue became to the attention of the United States. Oddly enough, for the first 200 years or so of federal Indian policy, notwithstanding the continuous dealings with Indian tribes, there was no federal policy that governed the idea that these indigenous communities existed and that the federal government had a responsibility to recognize them as such. Mind you, as I indicated, they continue to exist whether recognized or not, but the act of recognition, which didn't create them, but simply acknowledged their existence and is therefore sometimes referred to as federal acknowledgement, did give them the shield of federal protection. It gave them the shield that allowed them to stand immune from the application of state law in most respects, and that gave them a sphere within which to exercise more freely their rights of sovereignty. But nonetheless, that policy didn't exist for the first 200 years, roughly, of federal Indian affairs. Mind you, tribes were recognized, but they were recognized as an incident to some other federal activity. If the United States needed to settle peace with a hostile Indian government, they concluded a peace treaty. As a result of that treaty of peace, the tribe became recognized. If the United States desired land that was still occupied by a particular indigenous community, the United States again treated with that community for the purpose of acquiring their land. And again, as an incident of that treaty, that tribe acquired the status of federal recognition. So there were a number of tribes that were recognized in their indigenous capacity by the United States, but never as a self-conscious matter. This began to change in the 1970s, and it began to change as a result of really three different dynamics. One was on the West Coast, the fishing rights case that Charles spoke about, the Judge Bolt decision. Judge Bolt also declared, after his original decision in '74, he decided 2 years later that those rights, those continuous treaty rights, were not only vested in those recognized tribes that held them at the time, but also were maintained by tribes that for one reason or another were no longer federally recognized by the United States. So he established a process where these so-called unrecognized Indian communities could approach his court under a set standard and establish the right to participate in the treaty rights that he declared in 1974. All of a sudden then, for the first time in the West Coast, courts were beginning to consider, what does tribal existence mean? How do we adopt a standard that determines that, and what's the process that's going to be used? At roughly the same time, on the East Coast, the land claim cases had begun to be litigated again by the Native American Rights Fund. Early on in those cases, federal district courts in several determined that the Indian Trade and Intercourse Act, under which Congress purported to regulate the acquisition of land by tribes in a broad sense, was not related to or not tied to directly federally recognized tribes, that it applied instead to protect the lands of all tribes that existed as such. So again, federal courts were faced with the decision, how do we determine who those tribes are? Which tribes fall within the scope of the protection of the Non-Intercourse Act? Third, there was at the same time and shortly thereafter, deliberations by the American Indian Policy Review Commission, chaired by Senator Aberesk. And Senator Aberesk made it his business to ensure that that commission, among other things, examined the historic non-policy of federal recognition of Indian tribes. Through the deliberations of the American Indian Policy Review Commission, the Congress made it clear to the Department of the Interior that if the department did not act itself to adopt a policy regarding federal recognition, that the Congress would do so itself in the form of federal legislation. Senator Aberesk introduced a bill to do just that. So by the time of the mid to late 1970s, you had these three separate forces come together to produce such pressure on the department that finally, in 1978, for the first time, the Department of the Interior adopted a set of regulations governing the extension of federal acknowledgement to Indian tribes. NARF played a key role in the formulation of those regulations. Various attorneys at NARF, including myself, commented on those regulations and encouraged the department to finally take this step of establishing a process by which tribes that were not then federally recognized but had continued to exist as such could achieve the status of federal recognition. These regulations established a mandatory process that defined identified seven criteria that tribes must establish to prove themselves eligible for tribal recognition by the United States. These mandatory processes included criteria that had historically been looked to by federal courts, both by Judge Bolt and in the Eastern land claim cases, to identify an Indian tribe. They focused on the existence of a community that had continuously exercised internal political processes and that were obviously composed of indigenous people. It's that political process and that political classification that is key to understanding both the recognition issue and the tribal existence issue, whether or not recognized. Because it is that distinction, that political classification, that makes tribes unique under the United States Constitution. Because of that political existence, tribes are not racial classifications that may run afoul of the 14th Amendment. Instead, tribes are political entities. And because of that, the Supreme Court has ruled time and again that that exempts tribes from laws that would otherwise apply to review so-called suspect classifications of racial designation. It is not a racial designation. It is a political classification. So that became the focus of the regulatory process. These regulations were amended first in 1994. The one significant thing that revision to the regulations provided for was, for the first time, some acknowledgement of the fact that tribes that had been, quote, previously acknowledged by the United States were entitled to some special status or some diminished showing under the regulatory process. Now, in my mind, that raises a good question as to, if those tribes exist, why do they have to even come into this process at all? If a tribe is federally recognized, the rules under the Supreme Court have told us again and again that that's a unique status, that if granted by either the political branches or Congress, can only be taken away by Congress. Nobody can interfere in that special relationship unless Congress determines that it's going to modify or even abrogate that relationship. If that's the rule, and if a tribe can establish that at some point in its history it enjoyed that relationship with the United States, it raises the question then of by what power and authority was that right and privilege ever taken away from a tribe, such that the tribe was required to then again go through the administrative process to once again reestablish that relationship. That is an intellectual conundrum that no court, nor any administration has faced full on, and it results in some absurd conclusions. I'll just give you one example, which in my mind is particularly appalling. The Indiana Miami tribe, Miamis of Indiana, were in their Aboriginal territory, which became the state of Indiana from first white contact. They had treaty relations with the United States. As late as 1854, the Miami tribe signed a treaty with the United States by which the United States removed a number of the Miami people to Oklahoma, and the United States acknowledged that there would be Miami people remaining in the territory of Indiana who were allowed to stay on treaty-protected allotments for Miami people. For the next nearly 50 years, that relationship continued to exist. The Indiana Miami were deemed a federally recognized tribe. Nonetheless, in 1897, with the stroke of a pen, a lawyer at the Department of Justice said, because you've been allotted, I deem you to be no longer a participant in the process of the federal relationship. You are deemed terminated, and 75 years later, the United States said, now you must go through our administrative process. Those issues remain unaddressed. Let me briefly conclude with the following comments. We now have new regulations were ratified adopted by the department, promulgated in June of this year. We have a number of questions, like the question of previous federal acknowledgement, that remains facing those tribes. In addition, there is yet another status, another issue that has arisen of late, under which tribes that were not previously recognized are treated once again as second-class Indians by the federal system, particularly federal courts. And that is the 2009 decision in the Carcieri case. Since the Carcieri decision, tribes, even though they may spend 30 years going through an administrative process to prove that they have always existed as an Aboriginal community, now have to prove that as of 1934, they were under federal jurisdiction so that the department will have authority to accept land into trust for them. So at the end of the day, the process is not resolved. We still have second-class treatment of tribes who have been even recognized by the United States as a result of a painful process. And we hope for resolution of that issue one day, but that work still remains to be done.
Whoa, that's all right. First of all, let me say, wow! Here we are, NARF's 45th anniversary. And after these dynamic presentations by Charles, Arlinda, the opening comments from Mr. Gentry, and my heart just aches when I think of the Klamath. I hardly know where to start. you know, I started out as a lecturer at the university. That wasn't my idea. I got personally recruited by the chancellor of the university, his wife, Truman Lowe, an artist. Some of you may know his name. And he wanted me to come down. I was still chair of the Menominee Restoration Committee. And he wanted me to come down and join the faculty. That wasn't on my list of things to do, but anyway, the humans keep interrupting me in my plans, and it's been an exciting life. So I started out as a lecturer, then they promoted me to senior lecturer, then a distinguished lecturer, and my late brother says, well, better than extinguished. So I have termination, I have restoration, and following these speakers is a daunting task. And then I look out here and I think about all the connections that I have with you all, past, present, and future. And I could be immobilized, but I'm not. All right. So let me congratulate again NARF on its 45 years fighting for justice for our tribes and our people. Remember that Fighting for Justice t-shirt? Well, it's time to reissue it. I'm always telling them what to do. Sometimes they listen, sometimes they don't. I pick up the paper today, courtesy of my dear friend Lucille Echohawk. And what do we, you know, the press. We have to do something about the press. It says, Native American Rights Fund, group in Boulder, celebrates 45 years. Well, they got it half right. But speaking of priorities, and connecting it then to my further remarks, it says, John Echohawk was working for California Indian Legal Services in 1970 when the Ford Foundation provided a grant to start a pilot program to provide legal services to American Indians on a national level. So one thing that they got right here, the program led to the formation of the Boulder-based Native American Rights Fund to preserve tribal sovereignty and sovereign governments, to preserve tribal sovereign governments, protect the land, water, hunting and fishing rights, etc. So even though they didn't do the best job they could, they got the first priority right. So good for them. They need to be educated, continuous education involved. All right, drilling down here, preserving tribal sovereignty. And the nominees were terminated. I could spend a lot of time on that. I'm just going to say I was told once that the Menominees were the first tribe terminated, and we were the first tribe restored. And as part of this effort, I just want to say a few things about termination so you can have a context for the restoration. Some of you are VISTA volunteers, and let me say they played an important part in this too. Sometimes they don't get the credit they deserve. Our tribe was a federally recognized tribe from 1854 to 1954. We are still in our Aboriginal land. We have a beautiful forest, beautiful waters, and most real Indians have this deep attachment to the land and the people. Freedom with reservation. The Menominee struggled to save their land and people. Okay? That's always the basis of the struggle, and many other things flow from that, water rights and so on. Let me just highlight a few things. The Menominees did not ask to be terminated. We carried on a suit against the federal government for a number of years, 15 or 16 years, started in 1935, got resolved in early 1950s. We have this beautiful stand of timber. They grossly mismanaged it, and we won the suit, $8.5 million. It was then decided to introduce a per capita payment. We were one of the three tribes that paid for the services. We were basically self-sufficient, and people felt that it was important to have this money. I'm not going into all the details, but I just want to emphasize some of this. So it was agreed, Senator Joseph McCarthy and Congressman Melvin Laird introduced this per capita payment for $1,500 in the House of Representatives. Got to the Senate, before the Senate committee, Senator Arthur V. Watkins, he didn't know anything about Indians, and it was his decision that the Menominees, if they wanted their money, they would have to agree to termination. He came out, waved the $1,500 in front of them. 169 people voted for the idea of termination, 5 voted against it, and then he used this as a consent. Later on, the Menominees really started thinking about this, and they sent in a petition opposing it, signed by around 800 people. That was ignored. So from 1954 to 1961, there was all kinds of studies and so on that were done, but the end result was termination became final. And I want to emphasize, in 1961, I want to emphasize the fact that the Menominees were really not informed about this. They didn't understand it. They didn't have focus groups, and they didn't have informed consent, all these things that we kind of take for granted now in Indian work. So at any rate, I remember talking with a man who was in our traditional village. He says, you know, this termination, we don't understand it. You know, one day, you know, he's looking at his hands and he says, I'm an Indian, and the next day I'm not, but I'm still me, right? So, yes. And so he, in that statement, demonstrates the strength and the beauty and the spirit of Indian people in their own, recognizing their own personhood. Long story short, the tribal rolls were closed. 3,270 were on the tribal roll at the time. The land became subject to taxation. They set up a special corporation. It was a private corporation. See, this society always wants us to become capitalists, and I tell people that Indians are not born capitalists. They're born cooperating and sharing and caring. First thing they did was fire 150 men. They had to go because it wasn't profitable. Before that, the tribes could, if you're a member of the tribe, you could go and get a job in the tribal mill because that was the main basis of employment up there. Health, the hospital was closed. People were no longer identified as Indians. It was ghastly. It was ghastly, a political, economic, cultural disaster. And I want to read what the Menominee Termination Act, to provide for a per capita distribution of the Menominee tribal funds and authorize the withdrawal of the Menominee tribe from federal jurisdiction. One sentence. And it created such havoc, not only for our people, the Menominees, but for all the other tribes. And it's a permanent stain on the American governmental system. Pretty soon, they started selling land, and I'm a short distance away working at another university, and I took that job to be close to my tribe. And I'm reading that the Menominees are demonstrating. I said, what? You know, I have to go and find out about this. So I took a 2-hour drive, got up there, and the land sales were going on. I said, why are they selling the land? Well, they have to make money to pay the taxes. Anyway, I'm going to just drill down again. Many people left. People died. They didn't have health care. People couldn't go to school. It was ghastly to go from the so-called wealthy tribe. Actually, most of the people in the tribe were poor. There were certain classes of people that worked for the BIA, or they had a few other jobs like that around. At any rate, my own sister was in college at the time, and she, whoops, there goes the 5 minutes. I'm going to have to speed this up. She was going to quit, and I said, no, you're not quit. On my little social work salary, I paid her last year in college, so that was hard. So the despair of the Menominees was terrible. So they started demonstrating. I went up to find out about it. Found Joe Prelaznik, the OEO Legal Services Wisconsin Judicare lawyer. Talked with him, and the people were all, and they were in Milwaukee, they were in Chicago, they were trying to figure out what to do. And so we formed a group called DRUMS, Menominee Drums. There are many books that have been written about my tribe. And we then, through the help of NARF, I want to emphasize the position and the wonderful assistance we got from NARF. Charles Wilkinson and Yvonne Knight showed up. Joe Prelaznik called them in, so we had excellent legal help on the ground on a daily basis practically in Wisconsin. And then they flew in, and there were, I think it was approximately 1,800 hours that they spent flying back and forth. And so at this point, I want to thank the wife, Anne, and all the hours and that were taken away from the children, and the children also. The families really suffer from the absence of the NARF people. At any rate, it was decided we would formulate a bill, and we met, and this came from the grassroots of the Menominee. They decided through first these demonstrations, and then through excellent legal help we got from NARF, and we have, now I'm a permanent client of Charles, and I haven't seen Yvonne recently, but I'm going to track her down again. The deer gets tracking. Okay, so we formed fast friendships. We got the bill introduced in Congress. They were wonderful working there along with us. Yes, I was the lobbyist, but I want to emphasize the fact that you can't trust other people. You have to do it yourself. Yes, there are many, many lawyers out there and other kinds of people who get high prices. No, I dropped out of law school. I'm a law school dropout, but I succeeded anyway. And here I am talking to a group of lawyers here, and I have a love of the law, and maybe in my next life I'll be a lawyer. At any rate, the lobby, I didn't take any courses in lobbying. I just decided that, you know, this had to be done, and I was willing to exert every ounce of my energy and fiber of my being to get this done. And there's no substitute for that type of feeling and commitment when you're lobbying for your people and for other good causes. I want to emphasize that fact. Our drums people came in for some of the work there. I convinced the people that in Washington, Congressman Meads, that we should have a hearing on our reservation, which had never been done before. And we had a very good people in the Bureau of Indian Affairs at that time. Uncle Louis Bruce was the Commissioner of Indian Affairs. We had Ernest Stevens and Oneida, who was in the structure. And we had our NARF assistants, who, excellent assistance from Charles and Yvonne. I went to sleep at nights, and they were still arguing the fine points through the night. They were so dedicated. And we crafted the Menominee Restoration Act. The Menominees, grassroots, with good legal help, crafted the Menominee Restoration Act. And let me say, being a social worker, I'm not into dictating to people. I'm into empowering people. I didn't want to be, I got 1 minute left. Well, okay. I paid attention to the Menominee the words, the Menominee Restoration Act. I want to say what it says here. To repeal the act terminating federal supervision over the property and members of the Menominee Indian Tribe of Wisconsin. Now, lots of people in Washington, they like to put their marks on this. And one day I went into the BIA, and the lawyer said, well, I just came back from a meeting, and we were talking about wait, like, what were you talking about? Amending? No. I said, I have a bachelor's degree from Madison. I have a master's degree from Columbia. English is my first language, and there's a big difference between amend and repeal. Okay, this big tall guy, he said, okay. You know, so you have to pay attention to every word. And that's what Charles and Yvonne Knight did. They paid attention to the Menominees. They paid attention, and we had many arguments and discussions with the congressmen and senators, and I could tell you some. Senator Nelson, Senator Proxmire, Senator Kennedy, Senator Abresk. But we also had a lot of resistance. And that's a long story, but we overcame that. And when we all started this, we started with the care for the land. When the land started getting sold to white people, and I didn't want to have and they didn't want to see history repeating itself, they started. And then we went from these demonstrations to the sophistication of the law. And we had no real idea that this would be such a significant step in the history of Indian affairs. And let me say this. This is in your packet, the announcements, and so I would urge you to read it, but I would call your attention to the last few words here, and I might go over my minute here, but I can do that take a prerogative here, speaker's prerogative. Don't worry, I will summarize it after this. Okay, the act was passed in the House October 16th, 1973. Passed the House by an overwhelming vote of 404 to 3, and the 3 that voted against it didn't make it the next election cycle. That wasn't the reason, but I think it's for a good laugh. Okay. During the entire year, the Menominee plainly made their compelling case in the House of Representatives. We had subcommittee hearings, and I'm going to pay special attention to one of our elders, Ernest Nikanish, who was one of the oldest tribal member who was ambulatory. He spoke Menominee, and he loved wearing his attire, and he had a cane, and he would talk in Menominee to the people, and they didn't, to give them the experience of not knowing what was going on. And he was an avid advocate for us. Okay. Now, it passed the House, but then in the Senate, it kind of got delayed. And here's what it says. Again, the grassroots of the Menominees. We testified. The most comprehensive testimony during the entire legislation process was given by a panel of 7 Menominees, including Sylvia Wilbur, chairperson of MEI, Theodore Boyd, vice president of MEI, Ben Miller, chairman of the Menominee County Board, Ada Deer, chairperson of the Menominee Common Stock and Voting Trust, Robert Deer, vice chairman of MEI, and Carol Dodge, director of Menominee County Education Committee. These persons represented all segments of the community. Capitol Hill veterans said that they had never seen more complete or impressive testimony. And I think that shows, again, the strong spirit of tribal people using the political process to maintain their land and their culture and their people. The Menominees had learned how to make one part of the American political system work for the Indians. It is difficult to overestimate the significance of the Menominee Restoration Act. For the Menominee, it was the only realistic method of preserving their tribal existence, and for this reason, MRA has become a symbol for all Native Americans. Restoration is not the first reversal in U.S. Indian policy, but it is probably the most important one. It provides evidence needed to show that the American political system, imperfect as it has been and will continue to be, can be used as a tool to preserve Indian people and Indian culture. That's what it's about. So, thanks again to NARF.
Where am I? Cool. Thank you, Carlisle. We have. Bet you're right. You were excellent. Just excellent. I'm going to go ahead and start here because, get some technical things so I can do this little PowerPoint gig. But good morning. When I came to the Native American Rights Fund in the middle 1980s, one of the first things that I was assigned to work on was some Indian education work. And I can honestly say that Indian education is one of the areas where tribal sovereignty has been really hit the hardest. In addition to the federal policies, the historic ones that have been touched on today, the result in Indian education has been particularly difficult because, as you know, especially in kindergarten through 12, the elementary and secondary years of education in the United States, over 90% of Native American students attend state public schools, even on or near Indian reservations. That's how tribes have lost any kind of control or governance over Indian education. So part of my job for the past almost 3 decades has been to help tribes regain some sovereignty over especially K through 12 Indian education. So now that we have we need here, let me see if I can, So a lot of the work I've done has been to help tribes as sovereigns to regain that sovereignty. They need some kind of tribal education department or tribal education agency. I was fortunate when I came to NARF that there were already existing authorizations in federal legislation for appropriations for tribes as sovereigns in education. In 1984, as part of the Self-Determination Act amendments, there were authorizations to fund tribes for tribal education departments. Another one followed in 1988 through the Department of the Interior, appropriations for tribal ed departments as part of the Elementary and Secondary Education Act amendments. And another one in 1994. But alas, as some of us know, an authorization is just that. It's an authorization. You don't actually get any money. A separate step from Congress is needed called appropriations. Well, I was also fortunate in the couple decades at NARF, the first couple decades, that we had pretty robust funding for NARF to do a lot of the work that needed to be done to help tribes in this area of sovereignty over K through 12 education. We had Administration for Native Americans grants. We had foundation grants, Northwest area, Bush, Carnegie Corporation. Kellogg took a chance on us too. And looking back, I really appreciate all of this because what we were doing was pretty cutting edge and novel, the idea that tribes as sovereigns could have a role in state public school K through 12 education. The last grant we had was from the United States Department of Education. I'm kind of less involved in education, and the other point I want to make is that most of this funding it's been a good 10 years since NARF had any dedicated, significant funding to do the work in Indian education that needs to be done. The other thing that was really challenging was we had to do a lot of work in Indian country in this area because tribe leaders and Indian parents and everybody was used to the states providing the education. And then, oh yeah, there's committees and programs, and oh yeah, there's a few remaining BIE, Bureau of Indian Education schools, why don't you just send the tribal kids there, et cetera, et cetera. We had to do a lot of work with tribe leaders. And so we'd show up at every NCAI annual and mid-year meeting and explain to tribe leaders why they could still be sovereign in education, even though most Indian kids go to public schools, and what that meant. We had to work with the National Indian Education Association, which is a large membership organization, mostly of parents and Indian educators. And like Ada, there's no shortage of good role models in Indian education in terms of Indian educators and all the things they fought for, including the federal programs. How many people here have been participated in a Title VII, Title IV, or Title V program? Anybody here gone to a tribal college? Okay. All those things that Indian educators fought for were very important, but they also had to learn something about tribal sovereignty in education and what it really means for tribal governance. So we had a lot of work to do with NIEA. And one of the last grants we got from the U.S. Department of Education was to help start a Tribal Education Department's national organization, which goes by its acronym TEDNA, Tribal Education Department's National Assembly. That's now, well, gee, I was just in Portland at the NIEA annual meeting, and TEDNA had its meeting before that. And I think TEDNA is now a good 10 years plus, and it's an organization that NARF helped start and has worked with. So I'm happy the last couple years to report that we have made inroads not just in Indian country but in Washington, D.C. There are 2 pilot programs that the Obama administration has started to fund tribal sovereignty in education. The first one became in FY2012, the StateTribal Education Partnership Program run through the Department of Education. There's the website, which I know everybody's going to click on that right away. But there are 4 tribes and states that are grantees of this federal appropriations for tribal governance in education. And they are Chickasaw and the state of Oklahoma, Navajo Nation and the state of New Mexico, Nez Perce and the state of Idaho, and Umatilla and the state of Oregon. Okay, so again, we're talking co-governance in K through 12 education between states and tribes. And the BIE, the Department of the Interior, matched this somewhat in FY 2014 very recently with a new pilot program called Sovereignty in Education. There's their website. And the first grantee tribes are Standing Rock Sioux, Tohono O'odham, Gila River, Navajo, Turtle Mountain, and Oglala Lakota. So these tribes are participating in new pilot programs, getting federal dollars to help increase their capacity to govern in education. And then the Interior Department has come through recently with flat-out funding for FY 2015, $2 million. And there are the recipients of this: Hopi, Navajo, Standing Rock Sioux, Acoma Pueblo, Santa Clara Pueblo, Oglala Lakota, and Rosebud Sioux, which I'm proud of because that was one of the tribes that I worked with from the get-go. So all of these tribes are now, finally, we have accomplished getting the federal dollars to them. And that's not so weird. States all have education agencies. And about 40% of the operational budget for state education agencies comes from the federal dollars that they get. So there's nothing strange about this. What is important is that there's, these are some of the pilot tribes. There's 250 tribal education departments, though, around the country. We need more than just 2 million. So NARF will continue to work to help tribes in this area. And I think it's a very exciting time. I'm pleased to be a part of it. And there is a state, anybody here from, there's a new state that in 2013 became the first state by state law to authorize state tribal compacts in education. Anybody? Washington. So I just conclude because I think it's important. This is really historic. State tribal compacts in education. Gee, we got 250 gaming tribal state compacts. You've heard about the water rights compacts. So I always tell tribe leaders, you can do it for your revenues, you can do it for your resources, you better start doing it for your kids. This is what we need, is co-governance, and this is what NARF has put a lot into. The other area that I've been assigned at NARF is these tribal trust cases, some of which Charles alluded to. In 1820, the federal government started holding funds, mostly the money that it was paying to tribes for the land that it was taking by treaty, started holding these in trust, and as of FY14, the federal government says it still holds $3 billion in trust for over 250 tribes. The problem is that no tribe ever has gotten a full and accurate accounting of its trust holdings from the trustee. That is a long time and a lot of money for a trustee to have without providing an accounting. So when I came to NARF in the 1980s and 1990s early on, Congress was trying to address this, agencies were trying to address this, federal agencies, and private contractors like Arthur Andersen and Price Waterhouse were trying to address this. And no one could quite figure out what to do. So we took to the courts, and by 2007, over 100 tribes were suing the United States for breaches of trust, following the Cobell case primarily. And as was mentioned, it's now known that several tribes reached settlement agreements with their cases with the George Bush administration. The Obama administration has settled the cases of well over 80, almost 90 tribes for $2.8 billion or more. And to some extent, that is a reflection that it takes a long time to get these cases to trial, about 10 years if you can get it to trial. So again, you know, each tribe as a sovereign has an option to, if settlements are offered, to negotiate a settlement agreement. The other area at NARF that I worked on from the start was this area of tribal courts and civil jurisdiction over non-members. And actually, even before I worked at NARF, I was in law school, University of Michigan in 1985, when a visiting professor by the name of Charles Wilkinson was teaching Indian law. And this decision came down about tribal courts called National Farmers Union. And the court said that the argument that an Oliphant, U.S. v. Oliphant, which had been decided by the court in 1978, and said that tribes did not have criminal jurisdiction over non-Indians that were on reservations. That was tried to extend in National Farmers Union, and the court very clearly said, although not unanimously, that an Oliphant rule is not automatically extended. Civil jurisdiction is not automatically foreclosed like Oliphant. And of course, we've seen a number of cases, the Strait case in 1997, the Hicks case in 2001, the Plains Commerce Bank case more recently, where the court has kind of left open a lot of issues regarding tribal court civil jurisdiction over non-members. And of course, this term we have the Dollar General case versus Mississippi Band of Choctaw Indians, involving claims by the family of a Choctaw youth minor who was allegedly molested by the manager of the Dollar General store that operates on the Mississippi Choctaw Reservation pursuant to a lease with the tribe, and took on the youth as part of the tribe's youth program where youth get employment opportunities and mentored by businesses on the reservation. So this case will be argued on December 7th at the U.S. Supreme Court, and Dollar General is asking for the Oliphant rule, that tribes have been completely divested of jurisdiction over non-members. In the alternative, Dollar General seeks a rule that tribes do not have civil jurisdiction over civil torts committed by non-members on the reservation, or that if there is any civil jurisdiction in tribal courts over non-members, it is contingent upon an express and unequivocal consent by the non-member. So those are just some quick reflections on what I've been doing for 29 years, and hard to talk about it in just a few minutes, but I really appreciate the opportunity. Thanks.
Well, I guess it's my turn, like Charles, to know that I let all the ladies talk first. You know, this opportunity to speak at this NARF CLE is very important to me, because it's kind of a walk down memory lane to go through all the 45 years of NARF. And I picked the jurisdictional topic, which I think is a very difficult topic, especially for our tribes and our tribal citizens to understand. And I'd just like to say that I have some eye problems, so if I stumble in my reading of my presentation, I ask for your forgiveness. But I feel like all the other people that NARF has been a very rewarding experience for me. It gave me a good start, and it has continued to do so as I'll go through a kind of a history of Indian law for these last 45 years in the areas of jurisdiction, taxation, and a little bit on the trust responsibility. So I'll start by saying the federal government's abuse of American Indians from the time this country was founded to the 1960s is well known. Broadly speaking, tribes have always believed that tribal self-determination and believe that the federal policy toward tribes should be tribal self-determination. And for the most part of this history, the nation's history, the federal policy has been just the opposite. I joined Indian Affairs in 1965 when the official federal policy towards tribes was still the remnants of termination and transferring jurisdiction over tribal members, tribal citizens, and tribal lands to states under Public Law 280. Due to the federal government's failed policies, tribes had lost a massive amount of land, resources, and community, and American Indians suffered the worst socioeconomic indicators in the country. At this time, tribal governments, Indian activists, and any allies that we had were fighting against the federal government to retain our legal rights to political and cultural autonomy. Presidents Kennedy and Johnson worked on a program that became known as the War on Poverty through the establishment of the Office of Economic Opportunity. Through that program, the federal government created a community action program that awarded grants to various small entities and local governments, including tribal governments. This was an important program because it was the first time that the tribes and not the BIA received grants and could determine how the money should be used and spent. Through this program, many tribal governments had the opportunity to take over programs, account for funding, hire personnel, and publicize that the tribal governments were capable of lifting their people out of poverty and to engage in economic development. This was the first step toward the establishment of the federal Indian policy of self-determination. In March of 1968, President Johnson delivered a special message to Congress addressing the problems of the American Indian. In his speech, President Johnson announced the new policy of self-help, self-development, and self-determination for Indians and the establishment of the now defunct National Council on Indian Opportunity. Just a few months later, President Johnson signed the Indian Civil Rights Act of 1968, just 7 days after Martin Luther King had been assassinated. Then came President Nixon, who began the process of making Indian and tribal self-determination the overarching federal policy. President Nixon's special message to Congress on Indian affairs also declared, or also celebrates its 45th anniversary this year. He announced the new federal policy on July 8, 1970. Nixon's message to Congress led to the enactment of much landmark legislation that tribes still rely on today. The inertia for the self-determination movement consisted of, in part, of a small number of individuals working in the Washington, D.C. and in Indian country. These individuals worked behind the scenes in order to create positive change for Indian tribes through the federal government's elected officials. These individuals were Bobby Green Kilberg, who worked at the White House, Reed Chambers, who was associated with NARF, was the Associate Solicitor for Indian Affairs at the Department of Interior. Brad Patterson worked at the White House. Forrest Gerard, who was a staffer on the Senate side and worked for Scoop Jackson, the chairman of the Natural Resources Committee. Frank Duchesneau worked on the House side. He worked for Morris Udall, who was the chairman of the Natural Resource Committee in the House. This small group of people, along with the tribes and tribal attorneys, worked diligently to pass the Public Law 93-638, known as the Indian Self-Determination and Education Assistance Act. This act, as amended, is still utilized today to foster and promote Indian self-determination in Indian country. The energy of tribal self-determination grew enormously throughout the 1970s. With the help of the attorneys, including many at NARF, tribes and tribal citizens began the long overdue process of forcing the United States to comply with long neglected treaty obligations and redress for the federal government's longstanding failure to protect tribal interests and communities. As tribes and tribal citizens gained political and economic power, they often faced opposition, the resolution of which could only be determined in litigation. Most, if not all, of the attorneys that represented tribes and tribal interests during this period have worked at NARF or with NARF at some part in their careers. David Getches and Charles Wilkinson, with Charles' help, litigated the Bolt decision that gave the tribes of the Northwest, under their treaty, half of the commercial catch for fish. Rick Collins, who's sitting here, litigated and won a case on behalf of a tribal member to challenge the state of Arizona's ability to tax tribal members who lived and worked within the Navajo reservation. That case gave us the right to enact our own laws and to be governed by them. Dan Israel, John Echohawk, and Thomas Smithson litigated and won a case on behalf of a tribal member after the state of Minnesota assessed a tax on his on-reservation mobile home. These three cases represent a golden age of the Supreme Court's review of tribal jurisdiction. Through these cases and dozens of others tribal jurisdictional cases heard in that era, the Supreme Court repeatedly blustered and affirmed tribal sovereignty, relying on Indian law canons and the premise of the Marshall Trilogy that the policy of leaving Indians free from state jurisdiction and control is deeply rooted in this nation's history. However, as you all know, since the mid-1980s, the Supreme Court has reversed course. Foregoing the traditional principles of Indian law, the Supreme Court has created a largely incoherent and very fact-specific jurisdictional maze. Three cases stick out in my mind as the cases that at the time seemed like contrary, fact-specific exceptions to the long-standing principles of Indian law, but have since been cited repeatedly by states and the Supreme Court as binding precedent to further do away with tribal jurisdiction, totally ignoring the 150 years of precedent favoring tribal jurisdiction. One case is Oliphant v. the Squamish Indian Tribe of 1978, Washington versus the Confederated Tribes of the Colville Reservation 1980, and of course Montana versus United States in 1981. These cases, along with many others, have eroded tribal sovereignty and limited tribal jurisdiction over the last 30 years or more, and have led Indian tribes and Indian policy people to rethink litigating as a viable alternative to operating the sovereign and jurisdictional authority of our tribal nations. We have seen continued growth of internal tribal governmental infrastructure, which further tribal self-determination and relative stability to the tribal policy in the federal political bureaucracies. But in contrast, we see federal courts now only providing lip service to the strengthening of tribal governments while working to defeat tribal self-determination. Tribal jurisdiction as it is today is totally different than what it was in 1965. Further, as tribes continue to generate revenue from new sources, including Indian gaming, hotels, refineries, fisheries, wind farms, and smoke shops, the opposition to tribal jurisdiction and the intrusion into tribal sovereignty will similarly increase. One of the specific areas within the already niche practice of tribal jurisdiction that I believe will receive the most attention over the upcoming years is tribal taxation. Tribal taxation of Indians, Indian tribes, and non-Indians who work with Indian tribes doing business is extremely complicated and rife with pitfalls and untested law for even the most experienced Indian law practitioner. Indian taxation deserves serious consideration by Indian law practitioners, tribes, and perhaps most importantly, the United States government. While the BIA has begun the process of pushback against the legacy of cotton petroleum through the new leasing and right-of-way regulations, we still need a complete overhaul and undo cotton petroleum's dual taxation of Indian resources. In the matter of cotton petroleum, which was litigated by one of our NARF attorneys, but was litigated on behalf of Cotton Petroleum. There was no tribe involved, and our trustee was not involved, and so a lot of the facts that should have been in the record were not there because the tribe wasn't able to put forth the devastating impacts that dual taxation would have on them, nor was the trustee able to weigh in with their position as a trustee. And I think cotton petroleum is a perfect example of what a lot of you hear: bad facts create bad law, and we need to do all we can to reverse the cotton's dual taxation. The existing structure allows states to reap billions of dollars in taxation revenue from resources that squarely belong to tribes. This must be changed. State taxation of tribal resources is an intrusion to tribal sovereignty that harms the ability of tribes to develop their economies, replace their failing infrastructure, and to provide basic government services to their citizens. Another topic that I will address here is the disestablishment and diminishment of Indian reservations through judicial system. A tribe's land is the most important cultural and economic asset for most tribes. Yet this is another example of the Supreme Court and Federal Circuit's recent trend to ignore treaties and fundamental Indian law principles to invade tribal sovereignty and tribal jurisdiction. The major decisions on reservation diminishment greatly expand the magic language necessary to find a clear expression of congressional intent, even when the congressional intent is archaic, racist, or obsolete. Litigating this type of case is undoubtedly dangerous with the current judiciary, but in some times it's still necessary. For example, the Ute Indian tribe filed suit to prevent state encroachment on tribal jurisdiction back in 1975, and that case is still going on today. And the core issues in the case are the same as when the tribe filed suit: reservation boundaries and jurisdictional authority to prosecute crimes. Just this past summer, the 10th Circuit Court of Appeals ruled for the tribe in what has become known as Ute 6. Ute 1 through 6 span much of the same period of time that NARF has existed, and encapsulates the history that I have been discussing. The Ute tribe had to fight the court to retain its rights. The prior federal policy seeking to destroy tribes has presented significant hurdles for the tribe. Those seeking to diminish tribal sovereignty have been relentless. The Supreme Court pretends that harm to tribal sovereignty is a thing of the distant past, while it issues decisions which cause wide-ranging harm to those tribal sovereign interests. In 1963, it issued a devastating decision against the Ute tribe. The federal political branches have been unwilling and unable to take on the fight to protect the Ute tribe. Fortunately, because of the tribe's self-determination and the tribe's development of its economic resources, the tribe has been able to take on the fight and prevent further losses. Although the Ute tribe has had to litigate their jurisdictional authority within the boundaries of their reservation alone, they have been able to stave off the counties and the state of Utah, as well as the cities, in their efforts to exercise jurisdictional authority over their tribal citizens, where the crime is committed during the reservation, within the reservation boundaries and within Indian country. I know my time is up, so I'm going to just close by saying I didn't get a chance to talk about the trust responsibility, but I'll just say that, it's been my experience that the trust responsibility under the Obama administration has been gravely changed as a result of the Gobel litigation and as a result of the trust lawsuits. I've seen letters from congressional people telling Secretary Jewell not to do anything that would allow the Indians to have damages. And so the trust responsibility is now defined as don't do anything for Indians that would cause them to have a damage claim against the United States. And so that's a very serious position that we're in, and we need to work hard as Indian law practitioners to reverse that trend. And I thank you for your time. Thank you.